Punjab and Haryana High Court has quashed the law that was passed by the Haryana Assembly earlier, providing 75% quota in the private sector. It was controversial at the time. It provided 75% employment to local candidates with salaries less than 30,000 a month. Let's go across to Ghazali now for more. Ghazali, give us more details of what the court has said.
See, this was a plea which was filed by the Industrial Association of Gurgaon, and their main grievance was that this son of soil concept of the policy which the Haryana government wanted to create reservation in private sector was actually an infringement of the constitutional rights of the employers, because private sector jobs are purely based on the skills and the analytical blend of mind of the employees who are citizen of India. So it was also alleged in the petition that the act is an attempt to introduce a domicile methodology to get a job in the private sector rather than on the basis of their educational skills and mental IQ, which will create a chaos in the current industrial employment structure for the industries in Haryana. So the High Court, Punjab and Haryana High Court, has quashed this entire law which was introduced by the JJP government, and particularly it was the brainchild of the Dushyant Chautala-led Jan-Nayak Janata Party, and they wanted to score some brownie points. So it has been a big setback for the JJP as well as the Haryana government here, because Haryana goes to polls next year right after the Lok Sabha elections. So since the High Court has struck the entire law down now, it will have to be seen that whether the government will again challenge it, because even initially when this bill was introduced in the assembly, it was the JJP which was taking credit for it, and there were some voice of dissent from within the BJP as well. So BJP had never come out openly supporting this law. Now we will have to see whether there will be some legal recourse adopted by the government, whether the government will go for challenging this judgment of the High Court, and whether they will again approach the Supreme Court or another bench of the High Court to reconsider this decision.
Right, Ghazali. In fact, this case has been going on and on. It went to it was stayed by the High Court initially. It went to the Supreme Court, which removed the stay, but asked the High Court to decide on this matter expeditiously, given that there's so much at stake. And this also one needs to point out about how Gurugram next to Delhi is a place where a lot of multinational companies, a lot of various businesses have also come there. So many were concerned what the implications would be on such companies and industry.
See, the government had always argued that the law merely makes geographical classification, which is permitted under the Constitution, and it is to protect the right to life and livelihood of people domiciled in the state, and to protect their health, living condition, and their right to employment. But the industrial bodies of Haryana time and again have raised their objection to this law, and multiple meetings happened between Deputy Chief Minister Dushyant Chautala and the representatives of the industrial bodies of Haryana since this law was passed in the Haryana Assembly. But there were always resentment towards this law, and that is why now it is really a big setback for the Haryana government, because this was also being seen as one of the tools to bring back the Jat vote bank to JJP, towards the JJP, which has sort of gone astray after the farmers' agitation, because we had seen that how JJP is in alliances with the BJP in the government, and they had backed the laws initially before this entire protest went on for more than a year or so. So this is certainly a big setback, and now we'll have to see that how the government again moves ahead, whether to reintroduce the law or to challenge it in the Supreme Court as well.
That's right. They still have that legal recourse, but for the moment, a big setback, Ghazali, as you said, and this is something that they had been promoting, especially after, the farmers' protests, as you mentioned. A lot of support has been lost. But again, this offering of local employment and promising this to populations in states is something that we've seen in other parts as well. In Madhya Pradesh as well, Kamal Nath had said he would, do something similar. And now, if you could take us through what the High Court has said for quashing of this law.
See, when Haryana had introduced this law, they had cited the examples of other states like Maharashtra, that how they have also introduced a law on a similar lines over the domiciled people giving reservation to locals. And now, since the High Court has struck down this law, agreeing to the points what was mentioned by the industrial bodies, that it is a sort of a discrimination, and this law will always give an unfair advantage to the local people, and the recruitment will not happen based on talent and skills. Perhaps that has been accepted by or agreed upon by the honorable judges there. A detailed order is yet to arrive, is yet to be uploaded. So we are still waiting for that, and we are also awaiting the Haryana government's AG, the Additional General Advocate, the government's AG. So once they sort of share the details of the judgment on what grounds High Court have struck the law, or on what grounds the High Court must have given a judgment by either criticizing the government's policy or this entire rule of giving reservation to local people, or may also have given an option to the government to reconsider this decision. So we will have to wait for the detailed order from the High Court.
That's right, Ghazali. But also, just to explain to viewers, it wasn't as if, all 75% of all jobs were reserved for the locals. It was certain jobs that under 30,000 rupees a month, etc. If you could just, clarify that.
See, this law was introduced by the state government, and they had actually asked the industrial bodies to upload the details of all the job profile or vacancies which come under the category or where the salary slab is below 30,000, for which you have to the industrial bodies were asked that they will have to upload the details of all such vacancies, all such recruitment, and that had to sort of follow this law, that if you are recruiting anybody for a vacancy where the salary slab is below 30,000, you have to follow this law, or you will have to give preference to the local candidates. So this was the basic moot point of this law, that up to a certain salary level, you have to recruit local youths from Haryana, which has been opposed by the industrial bodies, and now it's struck down by the High Court.
All right, so that is the big breaking news we're bringing you right now. The Punjab and Haryana High Court has quashed this law that was brought in by the BJP-JJP government in Haryana, which provided for 75% job quota in the state. It was something that earlier the High Court had put a stay on. It went to the Supreme Court. The Supreme Court had removed the stay. But at that time, Ghazali had also said that no action will be taken against companies for, who are opting not to follow this law for the moment. It had been challenged in the High Court by various organizations that were very concerned with this ruling of providing 75% employment, and it was challenged, and now the High Court has decided on it. The Supreme Court had removed the stay but asked the High Court to decide on the matter expeditiously, and now, as Ghazali is telling us, the big breaking story coming in that the High Court has set it aside. If you could tell us also, Ghazali, some of the concerns raised by the private sector regarding this, quota law, and there was also concerns that this would then embolden other states, as you mentioned already, Maharashtra, and we've heard about it in Madhya Pradesh as well, but other states would also, bring in similar laws.
Yes, when the bill was introduced in the state assembly, the JJP was always talking about such states like Andhra and Maharashtra, which had brought similar laws giving preference to local youth. But what happened here is that the industrial bodies vehemently opposed it, because it was not just one organization, but any organization which employs even 10 people, minimum of 10 number of workforce was there, even they had to sort of abide by this law. So the main contention from the industrial bodies was that this is not going to only impact the big companies, but even medium and small and medium sector companies will also face or will also have to abide by the law, and that may impact their own growth and progress. And that is one thing which many industrial bodies, not just one, but there are different unions, and the government had to convene a lot of meetings with industrial bodies in Faridabad, in Gurgaon or Gurugram and other cities. And despite their in-principle approval during those meetings, saying that they agree with the government, they kept opposing it. And one of the prominent industrial bodies in Gurgaon kept approaching the courts, not only the High Court, but even they went to the Supreme Court. And after that continuous perusal of this entire issue, today the High Court has agreed with their viewpoint that this law may be in sort of the law may be on the basis of right to life or giving sort of a preference to domiciled residents. But in principle, it is also a discrimination against people who are not from Haryana, and they may be talented and they may be qualified enough to to get this job, and that is why the law has been struck down.
All right, Ghazali, we will come back to you. We are now joined on the phone line by Vineet Dhanda, former Assistant SG, Government of India. Sir, your comments on this law that was brought in by the Haryana government and now it has been struck down by the High Court.
Yes, I have heard about this, ma'am, but the Haryana government shall be filing the review before the Honorable Supreme Court in this. And the reservations are done for the welfare of people. Now, the court has used its wisdom and struck it down, but the same shall be challenged by the High Court before the Honorable Supreme Court by way of special leave petition.
Right, so there was a lot of resistance, though, to this law by various organizations, various companies, organizations as well in Haryana. They were very concerned. The High Court also finding that it went against, the natural justice. It did not provide for people from other states who may be able to get that employment that was being promised by the Haryana government to people of the state.
Yes. But we have to see the reservation also promised by the government is done as a welfare scheme only for different part of Haryana and for various people, so that people who are not able to get jobs through various sectors, they are assured by the way of reservation. So this scheme of reservation was a welfare scheme itself. But the Honorable High Court has struck it down thinking Article 21, right to life and right to other employment. So the basically constitutional rights have been restored by Honorable High Court. But the state of Haryana shall be challenging it as the government has also done a lot of work in providing reservation as well as giving employment to various people who are not getting through natural resources.
Right, sir, but at the same time, as I mentioned, a lot of concerns raised by corporates. You're also, the Haryana government has been pitching Gurugram as this, millennial city and asked people to come and open shop there. And this was a very big concern of the companies that are already established in Gurugram and other, Faridabad, etc. These places which are close to Delhi and therefore have been, very attractive for companies to come and set up shop. And there were concerns that this would put them off.
See, right to employment is a right of everybody, and it's a fundamental right. Giving reservation up to 70% might have been harsh on the private people and private sector. That is why the Honorable High Court has struck it down. But reservation does play a positive role in giving employment to those poor people who are not able to get it through normal regime. So, but the Honorable High Court has used...
If we talk about the caste reservation, that's very different. Here you're giving for a 75% reservation, across the board in the state to people who belong there.
You're totally correct. 75% is little higher the side of reservation. Up to 45-50%, it's still manageable. That is why the Honorable High Court has struck it down. But in my personal view, the state of Haryana will try to challenge this order by way of special leave petition.
All right. Thank you so much for speaking to us here at NDTV. We're also now joined by Ashutosh Srivastav, Advocate, Supreme Court. Ashutosh, if you could just, with this breaking news with the High Court having struck down the Haryana government's proposal for 75% reservation in jobs in the state, and the High Court has called the quota unsustainable, against natural justice. If you could just explain to viewers.
Yes, I have just seen the order of the Haryana, Punjab and Haryana High Court. I think the government may challenge this order before the Supreme Court on certain grounds, and that will depend as to how the government takes it up. The Supreme Court decides on this issue, but I'm sure this will be challenged, in the Supreme Court.
Elections coming up soon, so it definitely, as this was something that was pushed to appeal to the electorate, to the Jat community in the state as well. But the legal aspects of it, if you could explain what the High Court, why the High Court has ruled in this manner and found that it violates the Constitution.
Yes, see, there should not be, discrimination. That is one part of it. The citizen should not be discriminated under any valid law. However, we have seen in many instances, maybe with some amendment in the, in the existing laws, many a times the Supreme Court has also ruled out that with certain amendments or maybe changing or modifying the existing law, the same can again be can be confirmed or can be prepared, and the bill can be passed by the government by following the due process of law. So there are chances that with some amendment in the percentage and other aspects of the issue, the same can be decided by the Supreme Court.
All right. And the Haryana government, though it does seem that they will go to the Supreme Court over this matter, that is the big breaking news right now. Ashutosh, there are also concerns that, other states will also then bring in, rules like this already in Maharashtra. You had a proposal in Madhya Pradesh as well.
Yes, this is quite possible because there was already a judgment passed by the Supreme Court earlier where the maximum amount of the percentage of the reservation was already decided, and that should not exceed 50%. That was what already decided previously by the by the Constitution bench of the Supreme Court. And I think the same may be applied slowly in different states. And if the Supreme Court is of the view that the previous order which was passed by the Supreme Court also requires some kind of modification or changes, the same may be referred again back to the constitutional bench, which can be constituted by the Supreme Court itself to decide on that issue.
All right. Thanks so much for joining us. Well, that is the big breaking story right now. The controversial Haryana law, which mandated 75% reservation for residents of Haryana in the private sector jobs, has been struck down by the Punjab and Haryana High Court. The High Court termed it as unconstitutional, that there was discrimination in this law. In the law, and the Haryana State Employment Local Candidates Bill, that is what it was called. It was it went through several changes. It was passed in 2020, but after that, it was challenged in the High Court, and the High Court had earlier put a stay on this. The matter went to the Supreme Court, that removed the stay, but at the same time asked the Haryana government not to punish any companies for not following the bill, the law, till the High Court decided on the matter. And now the High Court has struck it down, calling it unconstitutional. What this law did essentially was provided 75% of private sector jobs with a monthly salary or wages less than 30,000, that those would then be reserved for people with a domicile certificate or residents of Haryana. Now, this domicile requirement also was changed. Initially, it was 15 years. It was brought down to 5 years. Let's go back to Ghazali for more on this. And Ghazali, so it does seem that the Haryana government will approach the Supreme Court over this matter. What you were saying earlier was also very interesting about the fact that how it was the JJP and Dushyant Chautala who were actually, really pushing this reservation, 75% quota for people of the state, and not so much the BJP. What would you say on that?
Yeah, certainly it was the brainchild of JJP, and it was brought in 2021. In 2021, the farmers' agitation was at its peak. There was a strong opposition to not only the BJP leaders, but also for there was a stiff opposition and resistance by the villagers on the entry and the political, gathering of the JJP, and sensing that it may spiral and it may stretch till the next elections. JJP sort of brought in this law while they were in coalition with the BJP in the government here, and this was basically done to sort of wean away those youths who had been opposing them due to farmers' agitation, to bring back to the party's fold or party's vote bank or party support in Haryana. So this certainly will be a big setback, because it has come at a time when already BJP-JJP government is facing anti-incumbency. They're also sort of the Chief Minister, Mr. Manohar Lal Khattar, has been visiting the entire state. He's already in the election mode. Both the parties already are campaigning in Rajasthan elections as well. JJP is fighting not with BJP, but they have fielded their own candidates on around 10 to 15 seats in Rajasthan as well. And there were talks that perhaps in the next elections, it will have to be seen whether both these parties will fight together. Leaders from both the parties have been voicing a strong opposition to the alliance, saying that we should fight alone. Dushyant should be the chief minister in 2024. So these political things are going on. These political developments are going on, sort of hinting a rift between the two parties. And also, when this law was enacted, was brought in the assembly, it was Dushyant Chautala and the party which took all the credit for bringing in this law. But since 2021, repeatedly, this issue has been raised in the Supreme Court. It was approached by the industrial associations. They went to Supreme Court. The Supreme Court had ordered that the government cannot bring this law. And what it said actually, the Supreme Court had said that till any decision on the constitutional validity of the statute is not decided by the High Court, the state government cannot take any coercive action against the industries for non-implementation. So it certainly gave some reprieve to the industrial bodies which are opposing it. But now, since High Court has struck it down, we are also gathering that the state government will challenge this decision, will challenge this verdict in the Supreme Court as well. So it will again go into the same legal process. It will have to undergo the same legal challenges. But as of now, it's certainly a big setback at a time when JJP is trying to find its political feet in Rajasthan. So it has come at a time when they are already in the campaign mode. They're already contesting elections. And how it will, what will be its fallout in Haryana if the law has been struck down? Because if the state government again approaches the Supreme Court against this verdict, it will be a long drawn process. It is not going to be resolved in 1 or 2 hearings. So we will have to see that whether and how strongly the Supreme Court defends it. How strongly the state government defends the case and how strongly they approach in the courts regarding this law.
Right, and how quickly it's decided on. Thank you so much, Ghazali, for joining us with all those details on this big breaking news right now that we've been bringing you. Unconstitutional is what the Punjab and Haryana High Court has called this quota that the Haryana government had passed. So 75% quota in the private sector in the state, and this has now been scrapped by the Punjab and Haryana High Court.